Hello and welcome to the second video from the sixth unit of our course on fundamental rights in the Indian Constitution. In this video, we will continue tracing the evolution of the law under Article 21 of the Constitution. ADM Jabalpur versus Shivkant Shukla, as we learnt in the previous video in this unit, was a decision in which the Supreme Court failed to interpret Article 21 in its true light. Justice Leela Seth notes in her biography that the judgment left her feeling like a pallbearer of liberty. Soon after the emergency, the Supreme Court began to make amends by interpreting Article 21 liberally. In Menka Gandhi versus Union of India, the petitioner's passport was impounded by the Union of India in public interest. The petitioner was a journalist. This was challenged by the petitioner in the Supreme Court. The contention of the petitioner was that the right to go abroad is a facet of personal liberty under Article 21. Further, the passport had been impounded soon after its issue without giving a hearing to the petitioner. The government claimed that the passport had been impounded to ensure the petitioner's appearance before an ongoing commission of inquiry. In Menka Gandhi, faced with these contentions, a 7-judge bench of the court revisited the relationship between Articles 14, 19 and 21. Recall from the last video on Article 21 that in A.K. Gopalan vs. State of Madras, the Supreme Court had adopted the narrow view that Articles 14, 19 and 21 are separate rights. The specific right that can be used to challenge state action, therefore, would depend on the intent of the state action. For instance, under the law in A.K. Gopalan, detention cannot be evaluated on the ground whether it violates freedom of movement, as it is intended to deprive a person of liberty as per law. You will also remember that this decision had been doubted by a 9-judge bench in R.C. Cooper vs. Union of India, where a test of direct effect was proposed. In Menka Gandhi, the Supreme Court abandoned the approach in Gopalan entirely and noted that Articles 14, 19 and 21 cannot be treated as mutually exclusive rights. What is the effect of reading Article 14 and 21 together? Recall from what we have already learnt in this course about equality that in the 70s, the Supreme Court interpreted Article 14 as a guarantee against arbitrariness. In Menka Gandhi, the court held that the procedure established by law should not be arbitrary. An immediate consequence of this interrelationship is that the procedure under Article 21 must comply with the requirements of natural justice. This finding in Menka Gandhi has inspired an entire generation of judges. The judgment of P. N. Bhagwati, who would go on to become the Chief Justice of India, has been cited in innumerable decisions to expand the scope and ambit of Article 21. To return to the facts of Menka Gandhi, the procedure adopted by the Passport Office in impounding the passport without any hearing was unfair. This was conceded by the Attorney General, who assured the court that a remedial hearing would be provided by the authority. On the substantive claim that there is a right to go abroad, the court conceptualized a new test to determine whether an unnamed right, such as the right to go abroad, is part of a named right. The contention was that the right to go abroad was a part of the right to freedom of speech and expression and the right to freedom of trade and profession. Let us unpack the new complicated test that was proposed. First, the unnamed right claimed must be an integral part of the named fundamental right. In this case, the right to go abroad must be an integral part of the right to freedom of speech and expression. Second, exercise of the unnamed right must in reality be only an instance of the exercise of the named right. An example given by the court of an unnamed right that fits this test is the freedom of press. It is undoubtedly an unnamed right within Article 91A, which guarantees the freedom of speech and expression. The court added a word of caution. Any activity that facilitates a right cannot be read into a right, or else even several mundane activities will also be protected as fundamental rights. Applying these tests, the court held that the right to go abroad, while it may facilitate the freedom of speech and expression, cannot be thought of as an independent fundamental right. The court, however, added a further caveat. The fact that the right to go abroad is not a fundamental right does not mean that the impounding of a passport cannot ever impact a fundamental right. Refining the test of direct effect conceived of in R.C. Cooper, the court held that the direct and inevitable effect of state action must be judged to see whether a fundamental right has been violated. The court gives several examples of an evangelist who wants to preach abroad, a foreign correspondent of a newspaper, a pilot with an international flying license, or a musician who wishes to perform abroad may all claim that an impounding affects their fundamental right to freedom of expression or their right to carry on any trade, profession, or calling. Without such a direct and inevitable effect on the petitioner's freedom of speech and expression in Menka Gandhi, the court held that the order of impounding did not violate the petitioner's right to freedom of speech and expression. The court, however, observed that the order would be unreasonable if it impeded her profession as a journalist and that the order of impounding was to operate indefinitely. On this issue as well, the court resolved it by recording a statement by the Attorney General that the order of impounding would not extend beyond 6 months.
We have analysed Menka Gandhi in some detail as it formed the basis of several fresh avenues for interpretation of fundamental rights. We can immediately identify two arcs of interpretation. First, the finding that the procedure established by law must be just, fair, and reasonable has had immense ramifications in constitutional law.
Recall from the previous video that the framers of the Constitution had worded Article 21 in its present form, that is, without using the term due process, to avoid granting judges the power to substantively evaluate laws made by Parliament. But due process review was now brought in through interpretation by requiring that laws that deprive a person of life or liberty must be just, fair, and reasonable.
This did tilt the balance in favor of judicial review, as the contents of these terms would be decided by judges from time to time. The impact of due process review is particularly significant in criminal law. We will explore this aspect in detail in the reading materials to this unit.